Hey there, deep diver. Ready to put on your legal thinking cap? Today, we're diving headfirst into the world of legal causation.
Buckle up. Because when it comes to the law, cause and effect, well, they aren't always as straightforward as they seem.
I was just thinking about that.
Yeah,
Like, on the surface, it seems pretty simple, right?
sure.
Something happens because of something else.
Right.
But when it comes to the law, obviously, it's way more nuanced than that.
Absolutely. Figuring out who is actually responsible for the harm, like legally responsible, that's where things get really interesting.
Yeah, it's like that age-old question.
Uh-huh.
Which came first,
Huh.
the chicken or the egg?
Right.
But instead of chickens and eggs, we're talking about, like, car accidents, medical mishaps, all those what-if scenarios that keep us up at night.
Exactly. And that's what we're here to kind of untangle today.
Okay, you, legal scholar for the day, let's start with the bedrock of it all.
Huh.
Actual causation. Now, I know you're thinking actual causation. Sounds a little redundant, right?
Well, in law, we love to be specific. We're not just talking about any old cause. We're talking about the action that directly led to the harm.
Okay, so how do the courts figure that out? Is there some sort of legal microscope they use?
You could say that. There's this thing called the but-for test. It's like our legal lens for zeroing in on that crucial link between action and consequence.
So is that like saying, but for this one thing happening, everything would be different?
You got it. Think of it like this. But for flipping a light switch, the light wouldn't turn on.
Right.
Similarly, but for the defendant's actions, would the harm have still happened?
Okay.
If the answer is no, then we're talking actual causation.
Okay, I'm starting to get the hang of this.
Good.
So it's all about that direct link between the action and the harm.
Yes.
But you're saying it's not always so simple to prove.
Right. Proving that direct link, it can be surprisingly tricky.
Yeah.
Take, for instance, the case of Muckler v. Buchel.
Okay, hit me with the details.
Sure. So a woman had a tragic fall in her apartment building on the stairwell, and turned out the lighting there was terrible, didn't meet building codes.
Oh,
The
okay.
court ended up ruling that, yes, the poor lighting, it was the actual cause of her injuries.
So if we think about it in terms of the but-for test, it's like, but for the dim lighting, she might not have fallen.
Exactly.
Okay.
But here's the catch. Contrast that with another case, Butts v. Weiss.
Okay.
Again, we've got a fall on some stairs, dim lighting is playing a role, but this time,
Yeah.
the court said, nope, not enough evidence to say for sure that the dim lighting was the cause. Other factors could have contributed.
So even though the situation seems similar on the surface, the outcomes can be totally different.
Exactly.
It all boils down to the evidence.
It does.
Get it.
It absolutely does. And this is where it gets even more complex.
Okay.
Imagine cases involving toxic substances, things like exposure to chemicals at work.
Right.
Proving that a specific chemical caused someone's illness, that's a whole other level.
I bet. Trying to isolate one single cause when there could be so many factors at play. That's like finding a needle in a haystack.
An apt comparison. We call these types of cases toxic torts.
Okay.
And a perfect example of just how tricky they can be is Cooper v. Takeda Pharmaceuticals.
Okay.
In this case, the plaintiff claimed that a diabetes medication was the culprit behind their bladder cancer.
Oh, wow. That's a tough one.
Yeah.
So how on earth do you even begin to prove that?
Well, in this case, the expert witness couldn't rule out every single other possible cause, right? But what they could say was that the medication, it was the likely cause.
Interesting. So it's not always about absolute certainty, but rather about demonstrating a strong probability based on the evidence.
Exactly. And that's what swayed the court in this case.
Wow.
But here's where we venture into even more uncharted territory. What happens when it's not a clear-cut yes or no about whether the action actually caused the harm? What happens when we're dealing with, shall we say, shades of gray?
Ooh. I'm intrigued. It sounds like we're about to enter a legal gray zone. Tell me more.
Imagine this. A doctor makes a mistake, something they shouldn't have done.
Uh-oh.
But their negligence, it didn't directly cause a patient's death, but it did reduce their chances of survival.
Oh, wow. That's a heartbreaking scenario.
Yeah.
So how does the law even begin to grapple with that?
That's where this fascinating concept called the loss of chance doctrine comes in.
Okay.
It's not about whether the defendant absolutely, positively caused the harm, but whether they decrease the likelihood of a better outcome.
So it's like acknowledging that even if the outcome wasn't a sure thing, the negligence still took away a real possibility, a chance for a better outcome.
Exactly.
That's incredibly significant.
It is.
It's like you said earlier, sometimes it's about shades of gray.
Yeah.
Do you have a real-world case that kind of illustrates this?
Absolutely. One that really highlights this idea is Falcon v. Memorial Hospital.
Oh.
Tragically, a mother died after childbirth.
Oh, no.
Now, it wasn't guaranteed that a specific medical intervention would have saved her, but
But there's always that question that what if, right?
right. And expert testimony in this case, it showed that this intervention, it would significantly increase her chances of survival.
Wow.
The court recognized that lost chance, that stolen possibility, and ultimately ruled in favor of the plaintiff.
It's amazing how the law tries to account for those what ifs.
Yeah.
But I imagine it gets even more complicated when you have multiple factors contributing to the harm.
Oh, absolutely.
It's not always just one cause, one action, is it?
You're absolutely right. It can be like trying to untangle a giant knot. And that brings us to multiple necessary causes.
Okay.
Picture this. A car accident involving several drivers, all being negligent.
Multiple drivers, all at fault. Okay, so instead of one smoking gun, we've got a whole arsenal of them.
Exactly. Each driver's actions, they all contributed to the crash, making them all a part of the cause.
Right.
Think of it like a puzzle where each piece represents a contributing factor, and when they all come together, bam, you get the accident.
Yeah.
McDonald v. Robinson, that's a classic case that
Yeah.
demonstrates this.
So if multiple parties are found responsible, can the injured party go after any one of them for damages, even if that person wasn't solely responsible?
Right.
Like, what if one person was only slightly at fault, but the other person was totally negligent?
You're thinking like a true legal mind.
Oh.
And that brings us to joint and several liability.
All right.
Let's say two defendants are on the hook, each 50% liable for an injury. Now, here's the interesting part. Under this principle, the injured party can go after either defendant for the full 100% of the damages.
Whoa. So even if one party was only partially responsible, they could still be liable for the whole thing. That seems kind of intense.
It is. But it also ensures that the injured party actually receives full compensation for their suffering.
That makes sense. It's about making sure that the victim is taken care of, regardless of who ends up footing the bill.
Precisely.
Wow, this deep dive is already making my head spin.
Yeah.
We've covered but-for, loss of chance, multiple causes.
It's a lot, right?
Who knew causation could be so complex?
Oh, we're just getting started. There's another twist to this tale of causation that I think you'll find fascinating. The multiple sufficient causes test.
Wait, there's more. Seriously.
Oh, yeah.
Okay, lay it on me. I'm ready for my mind to be blown.
Imagine two separate fires, each one capable of completely destroying a house on its own.
Okay.
Now imagine both fires merging, and as you might expect, the house goes up in flames. Which fire caused the damage?
That's a real head scratcher. I mean, either one could have done it, so how do you even begin to untangle that?
That's the million-dollar question, and it's where this multiple sufficient causes test comes in handy.
Okay.
It applies when multiple independent actions, each on their own, could have caused the harm.
Right.
And guess what?
What?
In these cases, the burden of proof, it shifts.
Ooh.
It's no longer on the plaintiff to prove the defendant caused the harm. Instead, it's on the defendants to prove their actions didn't cause the harm.
Wow. That's a whole different ballgame.
Right.
So it's like a legal game of hot potato where everyone's trying to prove they weren't the one holding it when the music stopped.
It's a great analogy, and Ford Motor v. Boomer is a fantastic example of this playing out in the real world.
Okay.
This case involved mesothelioma, a type of cancer linked to asbestos.
Asbestos, that's some scary stuff.
It is, and in this case, the plaintiff, he'd been exposed to asbestos in two different places, at his job at Ford and at a shipyard.
Oh, talk about bad luck.
Right, talk about bad luck.
Yeah.
Either exposure could have caused his illness.
So it's a real-life example of those two fires, both capable of causing the same harm.
Exactly.
So how did the court decide who was responsible?
Well, because of this multiple sufficient causes test, both Ford and the shipyard were held liable.
Wow.
They couldn't definitively prove that their asbestos wasn't the cause.
Right.
So even though each party could point fingers at the other, both ended up being held accountable.
That's wild. It seems like this test is essential for those situations where pinpointing one single cause is just impossible.
Exactly. It's all about fairness and ensuring that victims aren't left without any recourse in these incredibly complex scenarios.
Right.
And speaking of complex scenarios, just imagine a situation where it's impossible to know which specific manufacturer of a harmful product is responsible.
Okay, now that sounds like a real legal puzzle.
It is.
How do courts even begin to approach something like that? It's like trying to find a single grain of sand on a beach.
Right. It's mind-boggling. But this is where the law gets really creative.
Okay.
It's like, challenge accepted, get ready for this.
Right.
It's called market share liability.
Market share liability. Okay, you
Mhm.
definitely have my attention. That sounds like a whole other level of legal maneuvering.
It is.
What is that?
Well, picture this. You have a bunch of different companies all producing the same drug.
Okay.
Then, years down the line, it turns out that this drug has some seriously dangerous side effects.
Yikes, that's a nightmare scenario.
Yeah.
So then what happens?
Well, let's say someone was harmed by this drug. But here's the catch. They can't pinpoint exactly which company manufactured the pills they took.
Oh, wow. That makes it almost impossible to hold anyone accountable.
Right.
Right. I mean, if you don't even know who made the product, who do you go after?
You would think so, wouldn't you?
Yeah.
But the courts, they found a way.
Okay.
A landmark case, Sindel v. Abbott Labs, dealt with exactly this.
Okay.
A group of women developed cancer, and it was traced back to a drug their mothers took while pregnant.
That's awful. So are we talking about this market share liability idea?
You got it. They couldn't figure out which company made the exact drug each mother took.
Right.
It felt impossible, right?
Totally.
Yeah.
It's like trying to solve a mystery where all the clues have vanished.
Right.
So how did they even approach this?
The court did something pretty groundbreaking.
Yeah.
They said, okay, we might not know which company made the exact drug, but we can look at how much of that drug each company produced.
Okay.
So they held multiple companies responsible based on their individual share of the market for that specific drug.
That's amazing. So even though it wasn't clear which company was directly responsible for each individual case, the court found a way to hold them accountable based on their overall contribution to the risk.
Exactly. The bigger a company's market share, the more likely it was that their drug was involved, even if you couldn't prove it definitively.
Right.
It's a way of balancing the scales and making sure that victims have some form of recourse in these incredibly complex situations.
That's some serious legal ingenuity right there.
I know, right?
I love how the law is constantly evolving and finding new ways to address these challenges.
Yeah.
But even when you establish actual cause, you said the journey isn't over.
You're right. There's another layer we need to peel back here,
Okay.
and it's a big one.
Okay.
We've got to consider something called proximate causation.
Proximate cause. Okay.
Yeah.
Is that like the thing that's in close proximity to the harm?
Kind of.
Like physically close?
It's related to proximity, sure, but in more of a conceptual way.
Yeah.
Proximate cause, sometimes called legal cause, is all about whether the harm was a reasonably foreseeable consequence of the action.
Okay.
In other words, it's not enough for an action to be a cause. It has to be the proximate cause.
Oh, I think I'm getting it.
Good.
So it's like asking, was it reasonable to predict that this particular action could lead to this particular harm?
You nailed it.
Okay.
It's about foreseeability.
Okay.
Let me give you a classic example.
Okay.
Imagine someone leaves a banana peel on the floor, totally ignoring the potential consequences.
Okay. I can already see where this is going.
Right.
It's the classic slapstick comedy setup,
Yeah,
but with real-world implication.
exactly. Now, it's entirely foreseeable that someone could slip on that peel and get hurt. Right.
Right.
So if that happens, the person who left the peel there could be held liable.
Right.
But here's where it gets interesting. What if, instead of just slipping, the person who tripped sets off a whole chain reaction? Maybe they knock something over, which then causes something else to fall. And on, leading to a much bigger accident.
Ooh, that escalation. Talk about a ripple effect.
I know, right?
So in that scenario, you have to ask, was that final outcome, that big accident, a foreseeable consequence of someone dropping a banana peel?
You got it. And that's where things get tricky, because foreseeability, it can feel kind of subjective.
Right.
Where do you draw the line?
Totally. One person might say, of course that was foreseeable. It was bound to happen.
Right.
And someone else could be like, wait, how could anyone predict that? That's crazy.
Exactly. And that's where this idea of scope of risk comes in.
Okay.
How broadly or narrowly do we define those potential consequences?
Right.
Determining that scope, well, it's a critical part of this whole proximate cause puzzle.
Do you have any cases that illustrate this scope of risk dilemma? I'm always up for a good legal thriller.
Oh, I've got just the case for you.
Okay.
It's called Union Pump Co. v. Albritton.
Okay.
In this case, a woman was injured at work when she tripped over a pipe.
Okay. Sounds pretty straightforward.
Sounds pretty straightforward, right? But here's the twist. She was helping put out a fire at the time.
Okay, so the fire definitely played a role in setting the stage for that injury.
Right. You could argue that if there hadn't been a fire, she wouldn't have been in that particular spot, wouldn't have tripped over that pipe.
Right.
But here's the thing. The court ruled that the defendant's negligence in causing the fire, it wasn't the proximate cause of her injury.
Interesting.
They said the connection was just too remote. The
Wow.
fire was out,
Right.
and her actions were too far removed from that initial act of negligence.
So even though the fire was part of the chain of events, the court basically said it just created the conditions for the injury, but it wasn't the direct cause.
Exactly. It's about drawing those lines of foreseeability.
Right.
Now let's compare that with another case, Jolly v. Sutton, London Borough Council.
Okay, get me with it.
So in this one, we've got some teenage boys.
Sure.
They're messing around with an abandoned boat on public property,
Okay.
and they end up getting injured.
Oh.
Now, the council, they knew about this boat, but never did anything to remove it.
Well, that's just asking for trouble, isn't it? I mean, it seems pretty obvious that an abandoned boat is going to be a magnet for curious kids.
And the court agreed. They ruled that the council was liable because a child getting hurt while playing on or around that boat, that fell squarely within the realm of foreseeable risks.
Right.
It was a direct result of their negligence in not removing the boat in the first place.
So unlike the fire case,
Yeah.
the connection between the negligence leaving that boat there and the injury was much clearer,
Yeah.
much more foreseeable.
Exactly. And that's the crux of proximate cause.
Okay.
Drawing those lines, those connections, and saying, okay, this makes sense.
Right.
It's outcome, not so much.
It's like you're playing connect the dots, but with legal arguments.
Right.
But what happens when something totally unexpected throws a wrench into the works? Something that completely disrupts that carefully constructed chain of causation.
Ooh, I like where your head's at. You're talking about those, wait, what just happened? Moments in the legal world.
Yes, like a plot twist in a movie.
Right.
So what are those called in legal terms?
We call those superseding causes.
Superseding causes. Okay, I'm all ears. Give me an example. What kind of legal plot twist are we talking about here?
All right, picture this. You're running super late,
Okay.
and in a moment of forgetfulness, you leave your car unlocked, keys in the ignition,
Oh.
just for a minute.
Yeah.
Risky move, but we've all been there.
Oh, totally. I could already feel the anxiety building.
Right.
So someone swipes your car.
Yep. Someone spots that opportunity, jumps in, and takes your car for a joyride.
Okay.
Now, you were definitely negligent leaving it unlocked.
Right.
But here's where things take a turn,
Okay.
this joyride.
Yeah.
It turns into a high-speed chase with the police, complete with screeching tires, near misses, and a whole lot of chaos.
Oh, my God.
It ends in a massive accident.
Oh, wow. So now we're talking about a whole other level of consequences.
Right.
But would you be held liable for that accident? I mean, you were negligent, sure, but it's not like you forced that person to turn into a police chase.
That's the question, right?
Right.
And in this case, the thief's actions, that wild chase that would likely be considered a superseding cause,
Okay.
it's an intervening event so wild, so out there that it basically breaks that chain of causation.
So it's like saying, okay, yeah, I made a mistake, but how on earth could I have predicted that would be the outcome?
Exactly. And the law recognizes that
Oh, I know.
sometimes things happen that are so unpredictable, so far outside the realm of what's reasonable, that it wouldn't be fair to hold the original negligent party responsible.
Wow, superseding cause. Those are some seriously high-stakes legal plot twists.
They are.
Do you have a real-world case that showcases this whole idea?
Absolutely. One that comes to mind is Port Authority of New York and New Jersey v. Affiliated FM Insurance Co.
Okay.
It's centered around the tragic 1993 World Trade Center bombing.
That's a heavy one. So what was the legal issue there?
Well, the terrorists used fertilizer, among other things, to build the bomb.
Right.
The question became, could the fertilizer manufacturers be held liable?
Wow, that's a tough one.
Yeah.
Because on one hand, fertilizer isn't inherently dangerous, but on the other hand, well, we know how it was used.
Right.
So what did the court say?
The plaintiffs argued that the manufacturers should have, in a sense, foreseen this possibility, the potential for their product to be misused in such a horrific way.
I imagine that would be a tough argument to make.
It was, and the court ultimately disagreed.
Okay.
They ruled that the terrorists' actions, those were a superseding cause.
Okay.
Something so extreme, so outside the bounds of what's foreseeable, that it essentially severed that chain of liability for the manufacturers.
So even though fertilizer has the potential for misuse, the court drew a line.
They did.
The terrorist actions were just too far beyond the pale too unforeseeable to hold the manufacturers responsible.
Exactly. It's a heart-wrenching case on so many levels.
Right.
But it highlights how these superseding causes can appear and completely reshape the legal landscape,
Yeah.
especially in situations with such devastating consequences.
It makes you realize just how much complexity and nuance there is in the law.
There is.
We've covered so much ground in this deep dive. Actual cause, but for, loss
Sure.
of chance, multiple causes, proximate cause, superseding causes. It's mind-blowing.
It's a lot.
My brain is definitely doing a few legal pirouettes right now.
I bet. It's a lot to digest, for sure. But that's the thing about causation.
Yeah.
It's rarely black and white.
Right.
There's always that element of human behavior, of the unexpected, that keeps things interesting, to say the least.
And that's what makes these cases so fascinating.
Right.
Because it's not just about legal definitions. It's about understanding how those definitions play out in the real world with real people and real consequences.
You said it. And it makes you realize that even seemingly simple actions can have such far-reaching effects. It's a domino effect of responsibility.
Totally. So, for our listeners who are now feeling like armchair legal scholars after this deep dive, I have a little challenge for you.
Okay.
As you go about your day, think back on the cases we've discussed today.
Yeah.
Put yourself in the shoes of the judges and juries.
Yeah.
What would you have decided? Where would you draw those lines of responsibility?
It's a great exercise, and it's exactly what makes this area of law so fascinating.
Right.
It's not just about memorizing rules, it's about grappling with those big picture questions of responsibility, fairness, and what it means to be truly accountable for our actions in a world where the unexpected is always lurking right around the corner.
So true.
Mm.
And for those of you who want to dive even deeper into these captivating cases and explore more about the twists and turns of causation, we've got you covered. You'll find links to more information in the show notes.
Because knowledge, my friend, is power. And the more you know about how the law works, the better equipped you'll be to navigate its fascinating complexities.
Couldn't agree more. Now, before we sign off, be sure to subscribe to The Deep Dive for more fascinating journeys into the heart of intriguing topics, surprising facts, and thought-provoking conversations just like this one.
We've got a whole lineup of deep dives ready to ignite your curiosity, so hit that subscribe button and get ready to explore.
That's right. Until next time, happy diving.